My name is Elizabeth Rohl. I am the Circuit Court Judge in Pierce County, Wisconsin. I'm the only judge in Pierce County, so I handle all the matters that come through the court, sort of a general assignment. I think preparation is really the number one thing, and it may seem somewhat obvious, but if you really know your case forwards and backwards, it gives you an opportunity to really listen to what's happening and respond in the courtroom rather than trying to go through your notes really quickly to try to make sure you understand what's going on. I think especially in jury litigation, if you're in front of a jury trial, something like that, it gives you the opportunity to have a much more conversational style, and so that you can just have a discussion with the witness, which I think is really something that's easier for the jury to listen to and understand when they're there all day. So having that preparation, really knowing the ins and outs of your case backwards and forwards, means that you're prepared to step in and respond to anything that comes up while you're paying attention and listening.
All right, so I'm Ashley Morse. I am the newest judge in Rock County. I am part of the general rotation there, so I also handle everything but juvenile cases right now. I'm only the second woman, first person of color to be a judge in Rock County, so if you're ever in Branch 4, you'll see me. I would say I know nerves are a thing. That was very much a thing for me when I first started. My first trial, I stood up to give my opening and knocked a whole pitcher of water all over my notes. And so I was like, oh, this is going great. But try not to be nervous. Like, we all, have been there. We know what it's like to be in your shoes. But I would say try to narrow down your theory of your case, and because sometimes I think when people are new and they're afraid they're going to get it wrong, they kind of throw everything out at the judge to see if something sticks, or at the jury. And so, but I think really it's kind of more effective when you can really tell a story and speak to something specific. So I think that probably you end up being better researched, you've narrowed down the arguments, and then you're just more concise and clear. So I would try to do that ahead of time.
Confidence, a willingness to, and that confidence means knowing the subject matter, knowing the case, knowing what they're there to do, but also having the confidence to say, I'm not sure the answer to that, I need some time to look into it, because making something up is obviously the worst thing that you can do. So having the confidence to say, I'm sorry, but I don't know that, I can get back to you, really plays well, because it gives you some integrity and some, then the other words that you have said and the things that you've mentioned, I can take more seriously because you've admitted when you didn't know the answer to something else. So the confidence comes in two ways, and it may seem counterintuitive to that confidence piece to say that you don't know or something like that, but really that is what makes someone seem more confident in the courtroom. I would say overall, your integrity and your reputation are almost like currency in this field. And so making sure that you maintain that you're, every time that you come into the courtroom, that you know that you're building your reputation, not only for the judge in that courtroom, but for the entire legal community, so that you, every time that you are in the courtroom or doing anything related to the law, you're building that reputation that ultimately is going to serve you for your entire career.